Yeah.
They're undergoing. They haven't had time.
Good morning. Welcome to the House Criminal Justice Committee. The committee will come to order, and would the clerk please take attendance?
Chair Hope.
Here.
Representatives Andrews.
Here.
Carter.
Here.
Breen. Young.
Here.
Arbit. Devendorf.
Here.
Cerniglu.
Here.
Filler.
Yes.
Mueller.
Here.
Bazat.
Here.
Harris.
Here.
Bagul.
Here.
Madam Chair, you have 11 members present. You do have a quorum.
Thank you. Representative Andrews moves to adopt the minutes from the February 27th meeting. Without objection, the minutes are adopted. And I'll make my standard announcement. If you wish to speak today during testimony, please make sure that you get a white card to the clerk. There are some up here, and there are some in the back of the room, and probably in other locations too. We will now vote to refer House Bill 5392 to the House Judiciary Committee. Representative Carter moves. Madam Clerk, would you please call the vote?
Chair Hope.
Yes.
Representatives Andrews.
Yes.
Carter.
Yes.
Breen. Young.
Yes.
Arbit. Devendorf.
Yes.
Cerniglu.
Yes.
Filler.
Yes.
Mueller.
Yes.
Bazat.
Yes.
Harris.
Yes.
Bagul.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you. The committee will now go at ease at the call of the chair.
Call the committee to order and then.
Yeah.
Committee will come to order. We will now hear testimony on House Bill 5271. Chair recognizes Chair Hope for testimony.
Thank you, Mr. Chair. House Bill 5271 would basically update the current post-conviction DNA testing law to better reflect advances in technology, as well as to allow more people to apply and be eligible for post-conviction DNA testing. This legislation was first enacted in 2001, and the changes before you would include removing the requirement that the individual needs to be incarcerated to obtain post-conviction DNA testing. The current statute does not allow for that. The changes would include allowing access to post-conviction DNA testing in guilty plea cases. Guilty pleas account for 95% of all criminal convictions. But if you look at folks across the country who've been exonerated, about 18% of them were the result of guilty pleas. False confessions are contributing factors in about 25% of wrongful wrongful convictions. Sorry. Yeah, that's also bad. And there's a lot of data on this. Innocent people will enter guilty pleas sometimes because of stress, mental exhaustion, promises of lenient sentences, or even difficulty understanding their rights. My bill would reduce restrictions on the availability of testing to include those who were convicted before 2001. And it would also update the motion language for a new trial to put it in line with Michigan's post-conviction trial standard. The two statutes have similar language, but this change would make it consistent with Michigan's traditional post-conviction remedy. And I've been working with my former professor, Marla Mitchell-Sisson, on this language, and she is going to fill in all of the gaps I left.
Good morning. Thank you for having me. My name is Marla Mitchell-Sisson. I am the former director of the Cooley Law School Innocence Project, where I currently serve as counsel. I began teaching in the DNA clinic in 2002, about a year after the statute was passed. So I have firsthand knowledge of how cases have been handled up to this point in time. I also had to learn DNA technology as a not so young lawyer, but I've gotten over that. And I think one of the key reasons why this bill is so important is because we did not fathom in 2001 how much the technology would continue to improve. Just to let you know a little bit more about the Cooley Innocence Project's work, we've screened over 6,000 cases in our office, and we've filed approximately under 50 petitions since that time. And we have exonerated.
Sorry, could you say that again?
We've screened over 6,000 cases in our office, meaning we've screened 6,000 applicants. And we've filed under 50 petitions throughout the state of Michigan since 2001. That does not mean there has not been more DNA testing done in cases because, frankly, more recently with the inception of conviction integrity units throughout the state, we've worked cooperatively with the Attorney General's Office CIU and other CIUs to determine whether the elements of the statute are met or whether there's a reason in the interest of justice for testing material biological evidence. And there's no changes to the statute in that regard. The evidence needs to be material to the identity of the perpetrator. That serves not only the wrongfully convicted individual, but it serves the victim and the broader community because we have the potential through using DNA technology to identify the correct person. The proposed amendments will strengthen Michigan's DNA testing law by keeping with advancing DNA testing technology and helping to identify actual perpetrators. Importantly, these amendments will serve the constituents that I mentioned. So as Representative Hope said, one of the substantive changes to the law is to provide an opportunity for those who have been wrongfully convicted or those who are claiming innocence to request post-conviction DNA testing after a guilty plea. Nationally, DNA testing has played a role in over 596 exonerations. 66 of those exonerations were guilty pleas, and in about a third of those cases, whether they were guilty pleas or not, the true perpetrator was identified. In Michigan, DNA has played a key role in 17 exonerations, including 3 guilty plea cases. The one that I'm going to mention briefly today, and I'm sure that this case is going to be discussed later in testimony, is the case of Lewis Wright. Mr. Wright was convicted wrongfully in 1988. He was claimed to have confessed to the crime, although he denied that confession and it wasn't documented properly. And he entered a guilty plea to the crime after psychological evaluations found him competent to stand trial. He tried to withdraw his guilty plea at sentencing, and subsequently, of course, that was not permitted, and he served 35 years in prison for a crime he did not commit. The crime was a rape perpetrated against a young girl, and there was biological evidence collected in 1988. And I'm sure you're all aware that DNA testing was not really available at that time, but the evidence remained available. Not all of the evidence, but some of it. And what is really important, I'm going to talk more about process than the facts of the case, is that our office, through grant funding in 2009, began to screen guilty plea cases. So knowing that we could not ask a court for DNA testing, we knew enough about the causes of wrongful conviction by that time to know that some individuals who plead guilty are factually innocent. So we started a pilot program, if you will, to screen cases. Mr. Wright's case was one of the first cases that we identified as a potential for DNA testing. It was a stranger rape with a child, So the DNA would be very material to who the identity of the perpetrator is. And also, it showed some signs of wrongful conviction. The confession, there was favorable information in police reports that we don't know would have ever come out at trial, and we wanted to explore that case further. My office, myself personally, I worked with colleagues in my office and the police department, and we located the evidence, but that evidence wasn't found until 2014. Then, in 2015, I approached the local prosecutor because I could not file a motion for DNA testing, and I provided an argument basically for why it would be in everyone's best interest to test this DNA kit, and I was turned down. Fast forward, we continue to keep the case open, trying to figure out what we could do in order to get the DNA testing, and the Conviction Integrity Unit at the Attorney General's was established in 2019. So in working collaboratively with their office, we were able to agree to the DNA testing. That was in 2000, and I think it was prior to 2023. It was probably a few years before that, but unfortunately the evidence was now lost again. So it took us, again, the assistance of the Attorney General's office, and miraculously the evidence was found. It was tested, and again, I'd like to remind the committee members, this is a case from 1988, and DNA has the potential to last forever. And not only did we exclude Mr. Wright as the perpetrator, the DNA result was substantial enough, there was enough information to put that into the CODIS databank. So this is a great example of a guilty plea case in which DNA testing was more than appropriate, and unfortunately, Mr. Wright served 35 years in prison for a crime he didn't commit. The other change in the statute is when testing was done or not done in the case. And we just feel that that language is antiquated. When the statute was passed in 2001, there was a belief, perhaps a reasonable one at the time, that everyone would get appropriate DNA testing prior to trial after 2001. And that simply has not been the case. And surprisingly, I think our office probably has the highest number of applications that we've had in our entire history. That doesn't mean that we're going to be filing more DNA petitions, but it certainly means that the need for post-conviction DNA testing continues, and that change is to just make it more straightforward and to keep up with the improving technology. And the proposed language will do that, I believe, for another 20 years. We also want to make sure we clarify the definition of biological evidence, because the law references biological material as well as biological evidence. And again, because what we can DNA test, we can DNA test this piece of paper and potentially pull my DNA profile off of it. Those types of DNA technologies were not anticipated when the statute was passed, and so to provide a definition within the statute itself will provide uniformity and provide needed guidance for the courts. And finally, as Representative Hope highlighted, there should not be a restriction on anyone, whether they're in prison or out of prison, to pursue the opportunity for post-conviction DNA testing. I know this committee is aware that after a criminal conviction, there are a number of collateral consequences, including filing on the sex offender registry, and frankly, most of the cases that my office handles, and presumably the State Appellate Defender's Office handles, are murder and rape cases, because those are the cases that, frankly, very small percentage of cases overall that have DNA as evidence. So we want to make sure, number one, that Michigan citizens are able to pursue DNA testing and clear their name at any stage, particularly as the technology improves. And we want to ensure that victims and the broader community receive justice. So thank you this morning for your time and attention. This is a very important matter to our office, and it's been an honor to work with Representative Hope and other members of the committee in the proposals before you today.
Thank you very much. We have 2 questions. Representative Filler?
Thank you. And I guess before my question, I would say that, people who get their liberty taken away for crimes they don't commit, it's basically the worst thing the government can do to you, right? And we all acknowledge that. So I guess more what I'm asking is, is this bill a proportional step, or will it lead to a lot of new frivolous motions? Because 95%, I believe somebody said that, of convictions are guilty pleas. So that's going to open a lot of new convictions to motions and re-review on the DNA side. So I guess I do have a question. How many motions for post-conviction DNA testing have been filed? I don't even know if this is available since the statute went into effect in 2001. And how many of those motions have resulted in the grant of a new trial?
Well, again, I can only speak the data specifically to Michigan. I can't speak to that particular data other than the data in my office. I will say that my office was established in direct response to the DNA law, and so we are the office that does the bulk of the cases, and we've exonerated 9 individuals and assisted in 3 additional cases where we assisted with the attorney or another organization to obtain the DNA testing. And we,
how many-
as I said previously, we haven't filed a lot more motions as of late because either we agree to the DNA testing with the local prosecutor or with the conviction integrity unit, assuming we can establish a good reason for testing. But I would say we have filed roughly 50 petitions since 2001. If I may, Representative Filler, I'd like to comment on your concern or question related to the burden, the potential burden or filing of petitions. I think the starting point for that discussion really needs to be on how many cases involve biological evidence. And a very small percentage of cases overall involve biological evidence, roughly 10%. So again, in my 20 plus years experience, most of the cases that my office has reviewed and pursued DNA testing in are murder and rape cases and cases in which the defendant frankly has a life without parole sentence. So obviously the stakes are high, these amendments will certainly allow the opportunity for those who have pled guilty who can meet the other elements of the statute. It will give them the opportunity to file. But again, we received a grant in 2009 from the federal government, and we've screened hundreds of guilty plea cases and have only sought testing in 2 cases, and we assisted the State Appellate Defender's Office on a few cases as well.
So your take is it wouldn't be some sort of burden, massive burden on the court?
No, and in fact, many states have this provision in their law. Amanda Walwin will testify from the Innocence Project in New York, and I think around 44 states allow testing in guilty pleas, and there's no evidence nationally that this has placed a burden on any courts in any state. And again, I can speak from the same concern Representative Filler was raised in 2001, right? Rightly so. There was going to be a new avenue for folks to pursue a post-conviction claim, and the reality is that I have seen no evidence that 77016 has ever caused a burden on the courts or prosecutors. In fact, my experience has been that every case that I've ever gone into court, this was the judge's first post-conviction motion, and the first time the judge was presented with this law. Of course, I can't tell you today whether 500 people are going to file in guilty plea cases, but there are other very important and scrutinizing elements of the statute which will allow the court the opportunity to do its job and screen out the appropriate cases.
One more question from, from Representative Begol.
Thank you, Mr. Chair, and thank you for coming here today to give testimony on this important matter. So if this becomes law, people who were convicted prior to 2001 as a result of a guilty plea will now be eligible to file a post-conviction motion for the DNA testing, correct?
Correct.
Okay. Can you quantify how many people that may be and what the fiscal impact would be on the state?
Again, all I can base it on is our own experience in our office. So again, Mr. Wright's case was a prior to 2001 case, and we have another couple of cases that involve guilty pleas. We have a significant amount of federal grant funding, which allows us the opportunity to not only screen cases, but use those grant resources to pay for DNA testing and hire experts. And yesterday, we just ran some rough numbers in our office, and we had around 35 guilty plea applications in Wayne County. Again, it's guesswork on my part, but of those 35, we would screen those for all the elements of the statute, and also we work with conviction integrity units now, so sometimes we do test for broader reasons, ones that go beyond the statute. So I think that's really important, too, to take into consideration here, that the bulk of our work now is working directly with conviction integrity units, which means that we don't go to court. We make our arguments or take our position with the conviction integrity units, and we work cooperatively and agree to the testing, which places no burden on the court whatsoever. And so we are working cooperatively with the government in most of these cases, and we are agreeing that the evidence is important in the case, that it is material to the identity, and that testing it not only potentially could exonerate or support the defendant's innocence, but it might also identify the true perpetrator.
Just a follow-up question. Do we know of fiscal impact that this would have on the state to perform these
Because we
tests?
don't know the numbers, we don't know the fiscal impact, but I will say that I would think the cost would be minimal, that there would be very few cases in which we would proceed to DNA testing, whether that's through a court order or through cooperation. And the cost of DNA testing, frankly, has not been borne by the state for many, many years now. The Michigan State Police certainly does do DNA testing in our cases and in other offices' cases, but the Attorney General's office, my office, the Macomb County, the Macomb County CIU, we all have significant federal grant funding, which generally pays for the testing.
Thank you.
Representative Young.
Good morning. Thank you for the testimony. Quick question. I've been sitting here listening. So now, when using this DNA testing, we have an opportunity to allow people who, whether they pled guilty or not, and were innocent, become free again. But what I don't hear us talking about is the person who actually committed the crime. So now that we have a free person, do we find that this testing is leading to the actual perpetrator? Are you ever seeing anything like that? I'm just curious.
Yeah, absolutely. And so, again, it's hard to track those numbers. Our first exoneration, Ken Wynemko, 5 years after his DNA exclusion and exoneration, there was a CODIS databank hit to the true perpetrator. Nationally, there have been hits and identifications. The individuals representing those individuals who are claiming innocence, we don't determine if information is put into the databank, right? There are federal guidelines and state guidelines for that. But we do know that we get surprisingly good results in old cases. That's what happened in Lewis Wright's case. We didn't expect to get enough DNA information to get into the data bank. Our goal, frankly, in my office is to hope that the DNA science will exclude someone from a crime scene, right? That's our job, but it does serve that greater purpose. And yes, there are actually some, which I'd be happy to provide to the committee. There's some pretty shocking facts about what those individuals who are maybe later identified through DNA or even just a subsequent investigation, right? So in Mr. Wright's case, I don't know if there was a data bank hit. I just know it went into the data bank. But there's other information from the file that that local law enforcement and the prosecutor's office can use today to perhaps identify that actual perpetrator. And what we find in cases in which the actual perpetrator is identified through the data bank or other means, that individual, of course, has engaged in other criminal activity, sometimes to a huge or large extent. And so it's really a disservice to all of us. And the fact that we can get a result that identifies one person after an exoneration makes it worth it. Yes, you're welcome.
And then Representative Devendorf, and then if there's any other questions, we're going to move on. We have a lot of testimony today.
Can you remind us what the cost is to house somebody in a correctional facility every year, and then answer if DNA testing, regardless of who pays for it, it's cheaper than keeping somebody who's innocent in prison?
Yes, I didn't look at my MDOC figures this morning, but I think it's roughly $40,000 a year, 38?
I think it's 48 now.
Okay, 48, so I'm behind the times. I think there's a bit of a myth about the cost of DNA testing. There's certainly DNA testing is not cheap, especially if you don't have any resources. But the cost of DNA testing overall has gone down. It really depends on the particular case and how many items of evidence you need to test and what type of technology is needed. And again, I guess I'll end my testimony by bragging about my office, which is we had to become experts in this, not just experts in being lawyers and knowing the elements of the statute. And we treat the evidence in our clients' cases as a newborn baby. And we research and work very diligently to identify the most appropriate items and the most appropriate testing. Sometimes that comes at a higher cost, but we feel that this is a one-shot opportunity, and we want to get it right. And we rely heavily on experts and other forensic professionals to help us make that judgment. So to answer your question, it's much more costly to all of us to house a prisoner for even a year in the Michigan Department of Corrections than it is to do 3 rounds of DNA testing.
All right, committee will go at ease. Thanks. Hard day's work. Somebody's got to do it.
The committee will return to order. We do have a person from the Innocence Project, the national organization, Amanda Walwin, who's on Zoom.
Hi, thank you so much. My name's Amanda Walwin, and I'm a state policy advocate with the Innocence Project. The Innocence Project is a national organization that represents wrongfully convicted clients across the country. We also work to enact state-level policy reforms that prevent and reveal wrongful convictions. We support House Bill 5271, which expands access to post-conviction DNA testing, and thank Representative Hope for introducing this bill. Post-conviction DNA testing is a critical method of revealing wrongful convictions, and this bill could create a needed pathway for wrongfully convicted Michiganders who pled guilty and have been thus far unable to demonstrate their innocence. Post-conviction DNA testing has the power not only to prove innocence, but also to identify the actual perpetrator, thereby delivering justice not only to the wrongfully convicted, but also to the crime victim and the public. Permitting those who pled guilty to seek post-conviction DNA testing will not only increase the number of individuals proven innocent through DNA testing, The process of settling these claims of innocence will also enable the identification of the true perpetrators of the crimes connected to those cases. Of the first 375 exonerations based on DNA evidence, the true perpetrators were subsequently detected in 50% of those cases. These 165 people committed an additional 154 violent crimes while an innocent person took their place in prison. Nationally, it is estimated that 97% of criminal cases are disposed through plea bargain, not through trial. Currently, in Michigan, this means that the vast majority of people who have been convicted of a crime are not able to access post-conviction DNA testing. While the idea that someone would plead guilty to a crime they didn't commit may seem counterintuitive, many innocent people plead guilty, believing they are avoiding an inevitable and much harsher punishment. Nationally, 66 of the 596 DNA exonerations have been in cases with a guilty plea. The Innocence Project advocates against a guilty plea bar in DNA testing statutes to ensure that those people have the same chance to prove their innocence as people who are wrongfully convicted at trial. Across the country, only 5 other states exclude people who pled guilty from accessing post-conviction DNA testing: Arkansas, Delaware, Kentucky, North Dakota, and Ohio. 44 states and the District of Columbia do not have a guilty plea bar, and notably, no state has ever gone back after lifting their guilty plea bar. In every state that has made changes to their post-conviction DNA testing statute, none of them have ever seriously claimed that testing has caused a significant problem in their court system. While it's important to lift the guilty plea bar for the many people who are currently banned from accessing post-conviction DNA testing, it's worth noting that relatively few people take advantage of this opportunity when it is offered. A few examples include Cook County, in the largest county in Illinois and the second largest in the nation. Between the enactment of the state's post-conviction DNA testing law on January 1st, 1998 and late March 2002, fewer than 12 requests for post-conviction DNA tests were filed. Of those requests, 7 led to exonerations, an extraordinary success rate. Arizona, there were 45 petitions filed from the time the law went into effect in 2000 through 2012, according to the Arizona Justice Project. California has the nation's highest prison population and is nearly 4 times as large as Michigan. When its post-conviction DNA testing law was made effective in January 2001, the California Office of the Attorney General estimated that requests peaked at 20 per month statewide. It is now estimated that on average, there are only 1 to 2 petitions a month. In New York, 100 petitions were received during the first 7 years the law was effective, according to the Justice Project. In Texas, approximately 100 petitions are filed each year, according to a survey conducted by the Texas County Attorneys Association and the Texas Commission on Indigent Defense. And in Utah, 7 petitions were filed from 2002 to 2008, according to the Rocky Mountain Innocence Project. This demonstrates what we at the Innocence Project know. The truly guilty have no incentive to seek post-conviction DNA testing that will only confirm their guilt and negatively impact parole decisions. This bill will not open the floodgates to petitions from guilty parties. It's also important to recognize, as Marla mentioned, that in some Michigan counties, people who pled guilty already have access to post-conviction DNA testing in some circumstances. Conviction integrity units across Michigan will agree to DNA testing when they believe that the results may indicate a wrongful conviction. In those counties, the sky has not fallen. However, for wrongfully convicted Michiganders in counties where the district attorney doesn't have a CIU or the CIU doesn't see the value of testing that particular evidence, there's no recourse. This statute change will ensure that convicted people in Michigan have equal access to DNA testing, regardless of the county of their conviction. In short, this bill will allow for innocent people to demonstrate their innocence without overwhelming courts or prosecutors with fruitless requests. The Innocence Project supports this bill and encourages the committee to report it out favorably.
Thank you for your testimony. I'm now going to call up Robin Frankel, who's director of the Conviction Integrity Unit for the Michigan AG's office, as well as Ashley Steffen and Aaron Van Lungenfeld. And you can go ahead and get started whenever you're ready.
Thank you. Good morning, and thank you for the opportunity to address the committee on behalf of the Attorney General and in support of House Bill 5271. My name is Robin Frankel. I am the director of the Conviction Integrity Unit and the division chief of the Assistance with Convictions and Expungements Division. I've been with the department for 5 years. And before that, I spent 30 years as a criminal defense attorney. Because I've worked on both sides, I've also been able to see that the inability to obtain DNA testing has historically been a barricade on investigating innocence claims on both sides. The statute permitting testing, 770-16, successfully reduced those hurdles, but there are still a lot of hurdles for the people that remain incarcerated. We support House Bill 5271 in that it simplifies the statutory language and makes DNA testing more readily available to convicted persons. The bill sets out in plain language the prerequisites for testing and deletes a lot of previously convoluted explanations. It streamlines the process to request DNA testing and clarifies the court's duties and obligations. The Attorney General agrees that impediments to testing should be removed. No one benefits when the wrong person goes to prison. Not the victim, because we all know that that means the real perpetrator is still out there committing more crimes. Not the person whose life has been stolen away by the system that is supposed to protect it. And certainly not the rest of us who claim to be the protectors of our own communities. The best way to talk about our support is the case that Marla Mitchell-Sitchin already mentioned, and that is Lewis Wright. Lewis Wright was the most recent exoneration from the Conviction Integrity Unit and the Attorney General's office. When Mr. Wright was 30 years old and suffering from mental health deficits, he was arrested for the sexual assault of an 11-year-old. He was given one mental health evaluation, but when his psychological condition began to deteriorate in jail, and when his lawyer asked for an updated psychological evaluation, the court said no. His lawyer then somehow convinced him to enter a plea of guilty in order to avoid a life sentence. At the time set for sentencing, which was maybe a couple of weeks after his plea, Mr. Wright claimed he was innocent, that he felt forced to have entered his plea, and he begged the court to withdraw his plea. The response was that the judge told him to be quiet, and if he didn't want to be quiet, they were going to remove him from the courtroom and gag him and bring him back. So Mr. Wright got quiet, and he was sentenced to 35 to 60 years in prison, and so went his life. 35 years later, two of the lawyers that have accompanied me here today, they weren't born yet. 35 years later, because the Cooley Innocence Project could simply not bring themselves to close this file, and because Attorney General Dana Nessel started the Conviction Integrity Unit, we were able to work directly with the Calhoun County Prosecutor's Office and the Cooley Innocence Project to allow us to pursue DNA testing in a plea case with a sex assault kit that had never been tested. You see, because it was a plea case, Mr. Wright didn't have the ability to ask for DNA testing. He didn't qualify under the statute. It was only because the CIU stepped in. It was only because we have good working relationships with Cooley and because we developed a good relationship with the Calhoun County Prosecutor's Office that we all agreed to the DNA testing. And when that untested sexual assault kit was tested by the Michigan State Police, they told us it wasn't Lewis Wright. A few weeks later, Mr. Wright was released from prison. He is 65 years old. That's even older than me. He is finally home, and he's only home because of DNA testing. In this instance, we were lucky enough to find a prosecutor's office that worked with us and was agreeable to testing. But as the director of the Conviction Integrity Unit, I can tell you that's not always the case. Back in 2020, we sent out a letter to all 83 counties in Michigan, letting them know that we had received a grant from the Department of Justice to pay for post-conviction DNA testing, asking them to work with us where we could take on the burden, the expense involved, and work with us collaboratively. Every office doesn't agree, which is the other reason we need this statute. We do understand also, though, the need for finality in judgments. But let me say this, no victim has ever told us to stop what we are doing because the police might have gotten the wrong person. A victim's need for finality is the need to have the right person incarcerated and blamed. Our department has worked long-term to be a victim-centered office because the original victim is always the victim, even when the exonerated go free. But that doesn't mean that we allow guilty people to remain incarcerated in the name of finality. It doesn't matter how a person gets convicted. We can spend hours debating the idea of false confessions. Do they occur? Do they not occur? Why do innocent people plead guilty? But none of that matters. If an innocent person is convicted, all that matters is that we try to correct the wrong. We shouldn't be afraid of the science. That's the easy answer. If the DNA comes back that we got the right person, that is also a success for the statute, for my CIU, and for the state. Anytime the testing is available to establish either the propriety of a conviction or to identify an innocent person, it should be employed. None of us in this room favors the imprisonment of an innocent person. Certainly, the Attorney General does not. Thank you for this opportunity to testify, and I'm happy to answer any questions.
It looks like we don't have any questions, but thank you for
Good
your
for me.
testimony. Yeah.
Thank you.
Next, we'll have Jessica Zimbelman, who's the managing attorney at SATO and the co-chair of the Criminal Defense Attorneys Association of Michigan Policy Committee. Please go ahead when you're ready.
Good morning, everybody. Thank you. As the chair mentioned, my name is Jessica Zimbelman. I'm a managing attorney at the State Appellate Defender Office, and I'm here on behalf of SATO and CDAM in support of these bills. Everybody who's come before me has offered wonderful testimony, and we are supportive of all those comments and the changes in the bill. But I want to talk to you a little bit this morning as a criminal defense attorney about why somebody who's innocent would plead guilty. Because that doesn't make a whole lot of sense to a lot of people. Well, if you're not guilty, why would you ever plead guilty? And we've heard some numbers today. I would encourage the committee to view a really wonderful website called guiltypleaproblem.org. And that talks about how 18% of known exonerees pleaded guilty to crimes they didn't commit, as the chair pointed out earlier in her testimony. But what's really interesting about that website is that there are video testimonials of innocent people who pled guilty. And why? Why would an innocent person plead guilty? There's all sorts of reasons, perhaps reduced sentencing exposure, reduced collateral consequences like SORA registration, in certain jurisdictions to avoid the death penalty. Here in Michigan, it might be to avoid a life without parole sentence or other mandatory minimum sentences. It could be ineffective assistance of defense counsel. You got bad advice from your lawyer to plead guilty. Police and prosecutor error, junk science, mental illness or cognitive impairment, pressure from your family. There's a whole host of reasons why somebody who's not guilty would plead guilty. There is a case up for oral argument next week in the Michigan Supreme Court called People v. Samuels. And in that case, it dealt with twin brothers who were accused of a crime. And in part, the question in front of the court is whether promises of leniency to your family member can make a plea involuntary. And in that case, the American Psychological Association filed an amicus brief delving further into reasons why people might plead guilty, including, of course, leniency to a relative, but also intellectual deficits, a person who has a tendency to be compliant, people who have a high susceptibility to anxiety and fear, that those people are more likely to plead when they're facing external pressures from whatever source, including their own lawyers or their own family, to plead guilty. And I like to think about pleas as a high-stakes situation like an interrogation. And we know that under pressure, People can falsely confess in an interrogation. And it's the same kind of principle when you're looking at pleas. That APA brief, amicus brief in the Michigan Supreme Court, talks about how misunderstanding and fear are the most commonly articulated factors for why a person decides to plead guilty. And I want to highlight that's I hope interesting kind of research and background for the committee, but I do want to highlight a very recent case that the State Appellate Defender Office resolved through our wrongful conviction unit in partnership with the Wayne County Conviction Integrity Unit and the Cooley Innocence Project. This is the case of Terrence Calhoun, and I won't belabor the facts too much. But Mr. Calhoun pled no contest. He was 19 years old at the time of the offense, and he had cognitive impairments. He made a statement to the police, and I think the police mistakenly looked at that as a confession. But the exact details of why Mr. Calhoun decided to plead guilty are all the factors that I've talked about here. Some of the factors, right? He's young, he had cognitive impairments, he was facing pressure from various sources to plead. Well, it turns out after Mr. Calhoun had done 15 years in prison that he was not the perpetrator. DNA excluded him. This wasn't a case where a petition would have been filed under the statute because the testing had happened at the time of the conviction. So it was a Brady issue. Somehow this testing that exonerated Mr. Calhoun was not brought to his defense lawyer at the time. But he was exonerated because of DNA evidence. The real perpetrator was discovered, and Mr. Calhoun was freed. And I know the committee will hear testimony on the Wrongful Imprisonment Compensation Act bills later. Mr. Calhoun was able to receive compensation for the 15 years he spent incarcerated for a crime he did not commit. And one more very recent, as in last month, exoneration at Sado also came through DNA evidence. It was a trial conviction. It's not directly related to this, but the prosecutor's office did agree to test more biological material, exonerated Sado's client, and the real perpetrator, again, was discovered through that testing. So there are very real consequences for the people who have been wrongfully imprisoned and have their liberty deprived by the state, but also to protect the public by finding the real perpetrators. I'm in full support of these bills, and I'm happy to answer any questions that the committee might have.
Thank you. We do have a question from Representative Cerniglu.
Thank you, Chair Hope. More of a comment, but thank you for bringing this point of view. I actually was hoping that this would come up. I personally was a criminal defense attorney in a past lifetime, but I'm very appreciative of that point of view, because there are so many reasons why people might plead guilty when they're in fact not guilty. Going beyond even what you said, a lot of times the defendants will want to plead guilty because they think they will be convicted either way, because of their past experience with the criminal justice system, because of their experience just in the world in general. And they might say, well, I should probably plead guilty because then I won't get a harsher sentence, and it'll be resolved and it'll be done. And I personally was never encouraging of that. I liked the challenge of finding the evidence and getting those people, the justice that they deserved in those cases. And also from the prosecutor's office, a lot of times they will draw a hard line that if the people do not take those guilty pleas, then they're looking at something, that's very severe, and they may not want to challenge that just because of the past experiences. And also, sadly, I have, talked to people who, had other defense attorneys who told them they should just plead guilty, and maybe didn't even believe their own clients. And, to be perfectly honest, sometimes I didn't necessarily believe my own client, but I took it upon myself to, do that research, and go, do my job and advocate for what they wanted, they wanted to put forward. So, there are so many reasons. And, it's so important that we have the right people convicted, because if we don't, this is allowing people who could potentially be dangerous remain in society and commit further crimes. So I think if we want to be advocates for victims, if we want to protect victims and we want to be tough on crimes, then we need to pass these bills. So thank you for that point of view.
Thank you. Thank you for your testimony.
Thank you.
We are over time, so we're going to have to make some adjustments here. I'm going to ask that the folks who have personal stories, exonerees who may be on Zoom and maybe in person, I'm not sure, add their testimony at this time. So I'm going to call Ken Nixon, who's Director of Outreach and Community Partnerships for Safe and Just Michigan, as well as the president and co-founder of the Organization of Exonerees. Are you ready, sir?
Yes, I'm ready.
Please go ahead.
Good morning, everybody. My name is Kenneth Nixon. I am the president of the Organization of Exonerees. I personally spent almost 16 years incarcerated in the Michigan Department of Corrections for a crime that I did not commit. My group represents over 40 exonerees in the state of Michigan, and I am also a Cooley Innocence Project client. Listening to all of the testimony today, I want to highlight two very important points to anybody that may be on the fence about voting in support of this bill. And to be clear, the Organization of Exonerees and Safe and Just Michigan both support this bill. My testimony is in support. The first point that I would like to make is that what's not mentioned today is the very lengthy and arduous process that a person must go through to even be represented by an Innocence Project or a conviction integrity unit. Personally, going through that process, it took me several years before I was even able to be represented by the Innocence Project, which eventually led me to the conviction integrity unit. That years-long process entailed a whole lot of review before they would even agree to represent me, before an attorney would even agree to take on the case and walk me through the DNA testing. That part alone lends credibility to where the Innocence Project stands when it comes to innocence. Not very many people make it through that process because their innocence is in question or DNA is just not possible. In cases where DNA is possible, sometimes we have to battle. And that battle could be a life or death situation, because what we don't know is what condition that person is in while they're still incarcerated, while they're going through years of review from the conviction integrity unit or years of review from the Innocence Project, and then another entirely different battle through the court process. This DNA statute would allow that process to be shortened for innocent people. It's very, very difficult to know that your innocence is somewhere sitting in a box and you don't have access to it because of legal technicalities. That's a very difficult thing to process for anybody that's innocent. DNA testing should be available to everybody, pre-incarceration and post-incarceration. When innocence is on the line, it cannot be understated. The second point that I would like to make is, I think everybody that is a part of this hearing, in person and virtually, can agree that our prisons are filled with people that have mental health issues. We have a responsibility as a society to protect those people. Part of that protecting them means that we ensure we're getting the right person. Some people have developmental issues that don't allow them to fight back when they're going through the court process. They adhere to whatever the officer says. They adhere to the court process because they think they're doing the right thing sometimes, when in reality, they're not. They're harming themselves unintentionally because they don't know any different. We have a responsibility to protect them, and protecting them means ensuring that we get the right person. Our prisons should not be filled with innocent people. And the reality is there's tons of innocent people in prison, and DNA testing can prove that they're innocent. The process that currently stands, the process that this bill is asking for, requires no additional spending on the part of the state. The Innocence Project, or whatever party's coming forth, most often has the funds or has the resources to do DNA testing. There should be no reason why we can't do this.
Thank you. Any questions for Mr. Nixon? Thank you. We'll move on to Marvin Cotton Jr., who is Vice President and co-founder of the Organization of Exonerees, as well as CEO of Better Not Broken, and the Detroit Regional Coordinator for Nation Outside. Is Mr. Cotton here? Okay, he's not on Zoom, and he does not appear to be present, so we're going to move on. Kevin Harrington is on Zoom. He is the co-founder and board member for Organization of Exonerees and the CEO of Blessed and Highly Favored Always. Go ahead when you're ready, sir.
Good morning. Thank you guys for having me. In the position of a person that was wrongly convicted that served 17 years and 6 months in prison for something I didn't do, I was ultimately exonerated. DNA could have helped. It was DNA in my case in regards to touch evidence and things like that. But a lot of the red tape that's surrounding getting these evidence after so long of a time, the group that represented me was the Michigan Innocent Clinic. They couldn't get their hands on this type of stuff until Wayne County enacted the CIU. That's when we had a better hedgeway into the police department and things of that nature. We are, as a group and as a whole, especially coming from a person that went through those hardships of the courts just having so many barriers and loops and bounds to try to get evidence that could ultimately prove innocent or guilt. We support this 100%. And I like everybody on the community, Zoom and present, they are saying the same exact thing. Like, if a person that is not guilty of a crime should never serve 1 day in prison for something they didn't do. So I'm just asking the committee if there's anything that we can do to simplify or help that, we should. Thank you.
Thank you. Questions for Mr. Cotton?
Mr. Harrington.
Oh, I'm so sorry. That was my mistake, Mr. Harrington. My brain hasn't moved on apparently from the last person on my list. So I apologize, Mr. Harrington. It looks like we don't have any questions for you, and we appreciate your testimony. Next, we have Eric Anderson. Or we may not have Eric Anderson. Not on Zoom, so we're going to move on. Sure, we're gonna go ahead and move on to WICA. Representative Andrews will testify in support of 5431, along with Professor Mitchell-Sisson. And we are running low on time, and I apologize. I didn't want to give this issue short shrift, but we may have time if we can keep it moving.
I will do my best to keep my part very brief so we can keep things moving. This legislation addresses failure in the current law to meet what I think many of us would consider an essential purpose to compensate those who have been wrongly imprisoned, and to do so fairly and quickly. A few issues that exist with the current Wrongful Imprisonment Compensation Act is that the burden of proof is too onerous. Currently, the law requires a claimant to prove innocence by clear and convincing evidence, a standard that's usually reserved for when the government is looking at altering or taking away rights, a very unusual burden of proof to be using in a civil matter. This higher burden of proof goes against the purpose of compensating the innocent. Instead of being fair and swift, this burden of proof can often be insurmountable, particularly in older cases where evidence or records or witnesses might be unavailable for various reasons. The current law's definition of new evidence is inconsistent within the law itself, which leads to inconsistency in application and confusion. The law does not compensate those who are pardoned by the governor, and the law's offset provision includes attorney fees in the offset, which is money that the plaintiff does not receive. the law also does not compensate for time spent in jail or a mental health facility as part of the conviction, which can lead to a pretty large inconsistency as well in the amount of compensation paid out. So the solution that we're proposing here is to change the burden of proof to bring it more in line with other civil cases, provide a clearer definition of what new evidence means for consistency in application, allow those who have been pardoned to file for compensation, only offset the attorney fees after the damage is awarded and reduced for attorney fees, and include any time that the plaintiff is incarcerated for the underlying wrongful conviction as part of the compensation award. With that, I'll turn it over to you.
Thank you again. Good morning. Good morning, Marla Mitchell-Sisson. It's an honor to sit here with Representative Andrews and to see this proposal. I am not an expert on the Wrongful Imprisonment Compensation Act. I'm a Innocence Project lawyer, but this law has been very near and dear to my heart for many, many years. And when the law was passed initially in 2015, 2016, it fell soundly short. And that law took 12 years to pass. So I am delighted to be here to lend my support. I will keep my comments very brief and allow representatives from the Attorney General's office to talk about the details of how we got to this language. But it was a collaborative effort, and I think I can provide the best information by providing background information, which is there's no such thing as a declaration of innocence after you're after you've been convicted of a crime. The way in which it works is a motion is filed in court. The motion is granted, and then either someone is retried and acquitted, or the prosecution chooses to drop the charges. So this idea that we have factually innocent people who are clearly entitled to be compensated is a relatively new phenomenon. And many states do have compensation laws, and many of them fall short, frankly. But Michigan, I think, has worked really hard over the last 3 to 4 years to try to reflect on the law that we currently have in place and to make that law better, both in terms of its clarity and fairness to all Michigan citizens. So I won't re-highlight what Representative Andrews highlighted in terms of the changes, but I would certainly be happy to answer any questions about those changes.
We do have a question from Representative Filler.
Thank you, Rep. Thank you so much. Good to see you again. Can we talk about the burden change? So you get convicted, the burden is by beyond a reasonable doubt, which is a higher burden, but then we go into WICA and it changes to preponderance. I guess my question is, why would we have a different burden of evidence for the same case?
Well, WICA is not a criminal matter.
Right.
So the clear and convincing standard is typically a burden placed on the government when they're taking away our important rights. It actually goes, your question is really relevant in terms of my brief background information, right? Like, what is the best way to determine how someone should be compensated after they've gone through the entire legal process and essentially have return to that stage of a new trial. So we think that this approach is much more fair, because why should an exoneree, particularly someone who's spent very many years in prison, it's almost impossible for my office to obtain the documents we need to exonerate someone. And now the exoneree is filing a lawsuit and has the burden of proof and has to prove his or her innocence. I'm not crazy about that, frankly, but to the extent that we have to define a way in which to decide whether this person is entitled to payment, that is a fair burden, more than fair.
Thank you. And I don't see any other questions, so we'll ask the AG's office to come back up. And go ahead whenever you're ready.
Thank you very much. Good morning, and again, thank you for the opportunity of addressing the committee on behalf of the Attorney General and in support of House Bill 5431. Again, my name is Robin Frankel. I not only am the director of the Conviction Integrity Unit, but I've been the supervisor of the WICA unit for the last 5 years. Seated to my left is Assistant Attorney General Gallant Fish. Gallant has been working with me in the Wrongful Imprisonment Compensation Act section for the last 4 years?
5 years.
5 years, all right. Pretty much since I got there, Gallant's been there. He hasn't been alive as long as Mr. Wright was locked up, though. I've, again, been with the department 5 years, and in both my employment at the AG's office and as a criminal defense lawyer, I worked with folks who successfully challenged their criminal convictions, only to be released and face very realistic difficulties in reentry. You're talking about folks who've been locked up in prison for years, probably decades, many of them decades, and have zero on their plate when they come out. Some have no family or friends left to rely on. The WICA was the first step in mitigating those barricades. The passage back in 2016 was true bipartisanship, bipartisan co-sponsorship, overwhelming votes in support in the House, 104-2, and in the Senate, unanimous, and signed by Governor Snyder. Representative Andrews' bill represents the first substantive changes to that statute, and the proposed amendments are informed by the last 6 years of trying to apply the statute, and are the result of a work group that spanned almost 3 years. The work group on this issue involved all sorts of members from the Attorney General's office, myself and Assistant Attorney General Fish from the WICA unit, members of the Solicitor General Division, members of the Criminal Appeals Unit and the Habeas Unit. We worked alongside the University of Michigan Innocence Clinic and the Cooley Innocence Project. And what we wanted to do was establish and draft amendments that, one, remedied a number of difficulties that we were experiencing in the application of the law, and two, that both the innocence communities and the Attorney General's office could support. There are a lot of changes, but I want to just hit on some of the most substantial. Reducing the burden of proof, as we've already discussed, brings these cases in line with other civil litigation. Removing the requirement that new evidence was the reason for the dismissal. Allowing compensation to plaintiffs whose convictions were reversed on insufficient evidence rather than new evidence. Insufficient evidence meaning where a court has said, whoa, you never should have been convicted to begin with. That's not a crime. Allowing for compensation to plaintiffs who raise the issue of new evidence on appeal, but the court reverses the case on a different issue. Providing compensation where pretrial detention has occurred. Providing that the criminal trial record is admissible at a WICA trial. Example, we had a WICA trial, and the transcripts from the underlying criminal case were not admissible because they didn't meet the evidence rules. That meant that our office, Mr. Fish, had to retry a 20-year-old criminal case from the ground up. The statute, the amendments, simplify the payment of attorney's fees, define what is new evidence, and clarify the application where there are concurrent or consecutive sentences. Many of these changes were prompted by specific cases that highlighted the difficulties in enforcing the statute. There have been 5 or 6 Michigan Supreme Court opinions on WICA cases in the last 4 years. That's a lot. Example, removing the requirement that new evidence be the reason for the dismissal was prompted by our realization that more often than not, specific explanations aren't provided at the time a case is dismissed. How do you apply the requirement if nobody actually uses the words at the time of the dismissal? We have to evaluate whether there's new evidence of innocence. Regardless, it doesn't matter what they say. Similarly, clarifying the trial record is as I indicated, we had to relitigate a 20-year-old case. What we tried to do was offer amendments that made the WICA more workable, more equitable for the state and for the claimants. I'm going to stop my comments there. If you have questions, I'm happy to answer them.
I don't see any questions again. You must have done a perfect job 2 times.
Two down. Invite me back. Thank you.
All right, we do have some folks on Zoom who may want to testify as to the Wicca statue. Eric Anderson, I called you before and missed you. Are you on Zoom?
Yes. Do you want me to start my video or?
Sure, go ahead.
Okay. Good morning. My name is Eric Anderson. I served 9 years in the Michigan Department of Corrections for a crime I did not commit. I've been exonerated. I got exonerated in 2019. I support the Wicca bill because it gives individuals, a path to regain, some sense of hope, balance, and some kind of progression in life. A good start. That's all I have to say.
Thank you. Next, we have Lori Moore, who's also on Zoom.
Yes, I'm here.
Please go ahead whenever you're ready.
Thank you. My name is Lori Moore, and I'm 70 years old and live in Otsego County in northern Michigan. Please bear with me that I've had a stroke, and sometimes I can't spit out words as I'm trying to speak. I appreciate this bill is trying to fix the wrongful incarceration act. I am here to ask that you remember those of us who were harmed by those problems and amend this bill to allow us to benefit from these reforms. Here's my story that in November of '87, I was convicted of a crime I did not commit. I appealed my conviction on 13 issues. I was represented by Sato and Marty Tieber. At the time was the second in command there at the Sato office. The Sato appellate court overturned my conviction and ordered a new trial after finding that the judge in my case had given an improper instruction to the jury. The appellate court went no further and did not address many other issues that I raised in appeal, which is actually sometimes they go ahead and address all the issues raised in appeal, but in this case, they found in the first issue no reason to continue. The prosecutor then dismissed the charges against me, which I was free, but I received no reentry help from the state or compensation. And I had struggled many ways as a result of my wrongful conviction. I pretty much lost everything at that point. I had hoped that the wrongful wrongful Incarceration Compensation Act would have been available to people like me, individuals whose convictions have been reversed and who could, given a fair chance to establish what they had factually innocence of the crime for which they were incarcerated. Unfortunately, WICA excludes cases like mine. It requires that we show that our convictions were overwhelmed on grounds of new evidence of innocence. My case shows how unfair that is. I am not innocent. Excuse me. I am innocent, but had no control over how the appellate court decided to overturn my conviction. I actually had hoped that the appellate court would go ahead and address all of my 13 issues, but it's too late for that. As the deadline to apply for WICA compensation was approaching, I decided to apply it for no other reason than on the principle. I'm innocent and I can prove it. I accepted $25,000 in exchange for dismissing my claim. Actually, I was encouraged by my attorneys to do that. I didn't want to. I wanted to, by just in principle, not to accept it. But nothing was roughly 1/10 of not nothing, but roughly 1/10 of what I was due under WICA. I had I been given a chance to prove my innocence. Excuse me. I understand that this bill tries to fix that particular problem, and that in the future, all people with overturned convictions may be able to apply and have the chance to prove their innocence and be compensated. That is good. But what about me and others like me, who did not apply for WICA, and some of who didn't, and who were harmed by the problems you are now fixing? Justice may look back as well as forward. Rather than leave me and others behind, I'd ask you to amend this bill to allow those of us who were harmed by the problems you are fixing to benefit from those reforms. Thank you very much.
Thank you, sir. We do have a number of cards that will be made part of the record on both bills, and with no absent members and no further business before the committee will stand adjourned.